perspectives on compassionate release. The first witness is Margaret Love, who is testifying today on behalf of the Commission's Practitioners Advisory Group. Ms. Love is a practicing attorney specializing in executive clemency and restoration of rights after conviction, and was the United States Pardon Attorney for the Department of Justice from 1990 to 1997. She is joined by Marianne Mariano, who has been the federal public defender for the Western District of New York since 2008. She has also served on the Federal Defender Sentencing Guidelines Committee, served as a detailee to the Commission, and has testified for the federal public defenders at other Commission hearings. She's also a detailee, right, to the Criminal Law Committee, is that right?
Yes, I am.
So she does all sorts of good work across the country. Welcome back, and I'm glad you made it through that ice storm in Buffalo.
Thank you.
So, why don't we, I think, Ms. Love, are you the first? Okay.
Yes.
And here, I think I don't know if you've been warned about the light system. I don't know if you heard before, but I think here it's 5 minutes apiece or so, and then we pepper you with questions. Okay? Thank you.
I'm very, very pleased to be here, Judge and Commissioners. And I'd like to say on behalf of the Practitioners Advisory Group that we are very, very grateful for the Commission's inclusion of this item on its list of priorities for the coming amendment cycle. I'm personally very pleased to be here, having testified at the Commissioner's very, very first hearing on this subject in 2006, almost exactly 10 years ago. I'd like to make 3 points. The first goes to this issue of structure and legislative history. Congress intended this statutory sentence reduction authority to be administered primarily by the judiciary. To this end, it designed a balanced tripartite decision-making structure. This commission was tasked under 28 U.S.C. 994T with defining what constitutes extraordinary and compelling reasons warranting sentence reduction. BOP was to identify defendants in its custody who met the commission's criteria and then bring them back to the attention of the sentencing court. The sentencing court would then decide whether the defendant's sentence should be modified, applying general principles of sentencing. That is not how it works. At least in part because of this commission's modest view of its policymaking role over the years, BOP has played all 3 decision-making roles. It applies its own policies to determine when a case warrants sentence reduction, and those policies include consideration of factors that are committed to the sentencing court under 3553A, such as seriousness of the offense and likelihood of reoffending. In this regard, the United States Attorney's offices have come to play a very key role in BOP's decision-making process, frequently discouraging filings that BOP might otherwise be inclined to make. This is where a lot of cases get stuck, frankly, and I have heard from many people who have handled cases where a case gets stuck in the U.S. Attorney's office and is never seen again. Because a government motion is jurisdictional, the court has no ability to act even when it's sympathetic to a defendant's situation. The upshot is that what Congress intended as a judicially administered safety valve, a word that appears 3 or 4 times in the legislative history, is instead controlled by an executive agency responsible for prosecutions, which generally brings defendants back to court only when they are at death's door. The second point I'd like to make is that this commission can restore the proper balance to the decision-making process under 3582C1 by vigorous exercise of its policy-making authority. If the commission develops a detailed set of extraordinary and compelling reasons and a range of examples applying those criteria as required by 994T, this will facilitate an appropriate role for the courts in administering the statutory scheme and guard against unwarranted disparity. The clearer and more precise the policy developed by the Commission, the easier it will be to hold the Justice Department accountable for applying it in particular cases. In turn, if the department confines its gatekeeping role to deciding whether the Commission's criteria apply in particular cases, courts will then be able to play their intended part in determining whether the defendant's circumstances considered as a whole warrant sentence reduction. For this reason, we agree that the revised 1B1.13 ought to include a provision stating that the director of BOP should not withhold a motion if the defendant meets all of the criteria, any of the criteria, I should say, listed as extraordinary and compelling reasons in 1B1.13. I was really struck by Ms. Morales' comment about the difficulty that BOP has in determining whether individuals who meet the criteria are deserving. I believe that that's a decision for the court to make, with all due respect. The third point that we want to make is that Congress intended a broader scope for this judicial sentence reduction authority than is reflected in the current 1B1.13 or the BOP program statement. The legislative history of the Sentencing Reform Act indicates that the safety valve in 3582C1 was intended to apply whenever a defendant's changed circumstances make continued confinement inequitable, and that's a phrase that comes directly out of the Senate report. Not simply when a defendant is ill or disabled or aging, though we believe even these compelling reasons are too narrowly drawn in the current 1B1.13. We have a particular concern about the criteria for non-terminal illness and disability, which seem unnecessarily complex and limiting, and about the age-related criteria. We also urge the Commission to make clear that compelling reasons need not have been unforeseen at the time of sentencing. The only limit in the statute on the Commission's authority is that rehabilitation alone should not be a basis for sentence reduction. The appearance of the word alone seems to suggest that rehabilitation has some relevance and may be considered. In conclusion, we encourage the Commission to use its full policymaking authority to broaden and clarify the existing eligibility criteria under 1B1.13 and to give serious consideration to including additional categories of changed circumstances, such as changes in the law that have not been made retroactive. We've appended to our testimony a marked-up version of the Commission's proposed amendment to 1B1.13 and would be happy to answer any questions you may have about it.
Thank you, Ms. Mariano.
Thank you. I'd like to thank the Commission for giving me the opportunity to testify today on behalf of the federal public and community defenders regarding compassionate release and later regarding the conditions of supervision. I'd like to thank our Sentencing Resource Council for preparing our written testimony. I am particularly thankful that it is not 100 pages long, but I wouldn't want our brevity to be read as our opinion that this is unimportant, quite to the contrary. Defenders are pleased that the Commission is revisiting the compassionate release guideline. It is important to do so and to do so now because the current process is broken. Individuals who are dying or who are desperately needed at home to care for aging parents or sick children are being kept in prison longer than necessary. To fix this problem, we support the proposed amendment submitted by the Practitioners Advisory Group and agree with the reasons set forth in their testimony as to why the changes are necessary. In my oral remarks today, I want to focus on two things. First, the Commission has a very important role to play in addressing the current problem with compassionate release because Congress delegated to the Commission, not the Bureau of Prisons, the authority to define extraordinary and compelling reasons that should trigger a motion for a reduction in sentence. And second, we, the defenders, can help. The Commission should encourage the Bureau of Prisons to reach out to defense counsel or the defender in deciding before deciding whether an inmate meets the criteria for compassionate release. As to our first point, we encourage the Commission to adopt a comprehensive guideline that defines extraordinary and compelling circumstances independent of the Bureau of Prisons policy and makes clear that the BOP should file a motion for a sentence reduction if those criteria are met. In our view, Congress did not intend to delegate exclusive authority to the Bureau of Prisons in deciding what extraordinary and compelling reasons merit a motion for a reduced sentence. Congress explicitly gave the Commission that role, the role of setting the standard, and gave the judiciary the penultimate role of determining whether a person should have a reduced sentence. The statutory scheme is clear, and the Commission must lead. In addition to defining extraordinary and compelling circumstance, the Commission should also amend the guideline to instruct the Director of the BOP to file the motion when the criteria set forth are met. There's sound legal basis for doing so, and it could have legal effect. Under well-established principles of administrative law, the BOP's construction of 3582 is not entitled to deference because Congress spoke directly as to which agency or authority should define extraordinary and compelling reasons, and it is this one. There is no gap for the BOP to fill. No weight need be given to its policy statement by this Commission. Moreover, even if it could be argued that Congress left a gap, the BOP has now filled it. Their decision-making process on whether or not to file a motion is not entitled to deference because it's unreasonable, which we've outlined in greater detail in our written statement. Even if the guideline is not binding, the Commission's independent work on expanding Section 1B 1.13 is essential, and its guidance on a compassionate release will likely have an anchoring effect and play a significant role in BOP decisions on when to file a motion. The BOP exists over time, and despite its testimony here today, we fully believe this Commission taking the lead will influence that important agency. Finally, we can help. Defenders can help. The most startling thing in preparing for this today was how very little contact we have with this issue. The BOP should be encouraged to solicit information from defense counsel, before declining to seek a reduction for an inmate. The BOP collects information from the U.S. Attorney, the prosecuting attorney at times, the victims, and the Office of Probation and Pretrial Services when making this life and death decision on whether an individual meets the criteria for compassionate release. This fact-finding decision-making process would be more equitable and much improved if the BOP also involved defense counsel, who can help gather the many records the individual is required to produce. Counsel can also confirm, clarify, or refute information provided by the prosecutor or contained in the PSR, ensuring that the BOP has accurate information upon which to base its decision. As the process stands now, there are horrible inequities. Inmates of means can and do hire counsel to fight for them, while indigent languish without help in their hour of need. We can help. Accordingly, we request the Commission to encourage the BOP to contact defense counsel of record or the federal defender in the district where the person was sentenced or where they will be released. If the BOP is unwilling to notify defense counsel before deciding whether a motion to file compassionate release should be filed, it should at least notify counsel when the decision to make the motion is made and the issue sent to the court. Thank you.
I have a question on that last point. Did they not serve counsel with a copy of the motion?
No, they do not. We are, I have been in the defender's office for 21 years, Your Honor.
Yeah.
I have had contact with two issues. One was a white shoe law firm attorney from New York contacting me to see if I could help when a motion got stuck in chambers in our district. The second, very informal contact, obviously. The second actually was just this past year. The Bureau did, in fact, make the motion. The judge did, in fact, ask probation for the release plan and was inclined to grant it. And probation refused to approve the home where the person would be sent to live with his family because it was Section 8. Well, Section 8 does not bar a person who is terminally ill from temporarily, as that is temporary, living with a loved one. But the probation office, and I come from a district with a great probation office, did not act and did not act timely, and the BOP actually did reach out or suggest that the family reach out for us. And when we got the call from the family, we contacted the BOP, who was grateful for our assistance. We have many contacts, especially through our reentry program, that can facilitate this. So no, they do not contact us at all. But in this instance, because the family was very excised and the person was very near death, we were able to provide assistance.
This is, I guess it's for both of you, but I'll start off with this. In your testimony, you had mentioned that, or suggested that maybe DOJ in filing this motion shouldn't take into account the public safety factor for this. I'm looking at page 4. When looking at, so it's footnote 7, that it doesn't look like the department's authorized in deciding whether this exists to take into account whether the defendant's a danger to public safety, because another provision explicitly says it, and so the idea is it's silent here. I got to admit, that struck me as, we certainly have in the guidelines public safety, and 3553A would have public safety be part of it. And so it's a two-parter. So the first one is, are you standing by that public safety is not something for BOP? And then if you assume that it is, that it's got to be something that BOP takes into account before they file the motion, the question would be whether that kind of swallows up any other reform. Because, I understand what both of you have been saying about how we could give more specifics, how we could give more examples, how we could go through all of that. But if at the end of the day, BOP will weigh that against public safety, and if you assume, but maybe I'm wrong and you can convince me that it's not in there, but if you assume public safety has to be something that BOP takes into account, then I'm not sure where it gets us at the end of the day, because it seems like a lot of this is BOP saying no, because it's just we're weighing it and we just think the public safety weighs too high, we're not going to file it.
I was struck in reading the statute. I had never read it the way I did in the past couple of weeks, where the 3582C1A2, which is the 3 strikes, 30-year authority, does task BOP with determining, as a matter of eligibility, whether the defendant is a risk. However, that same authority is not in C1, or A1, I should say. And that was sort of interesting to me. Obviously, BOP has information relating to discipline and different things that have gone on that it would be tremendously important for the court to know. And of course the court would take that into account as a matter of 3553A. But as a matter of threshold eligibility, the way we read the statute, it doesn't look to us as if that should be a disqualifying factor at the threshold, but should be taken to the court.
So you're saying if BOP, I'm going to give you a stylized hypothetical here, okay, so just bear, but BOP looks at someone and they say, oh my gosh, the prison record is, off the charts. This person has really had lots of behavioral problems in prison, but they meet the terminal illness and the age requirements. So we'll go ahead and we'll file the motion and we'll just but we'll tell the court we don't think you should grant it. That's the model that you think this imposes?
Well, frankly, yes. I think as a matter of statute, reading the statute, that's the model.
What
Yes.
would be your response to DOJ's argument, though, that it says they're supposed to look at the 3553A factors, that, all of this is BOP has this gatekeeping role, and as long as they're supposed to look at 3553A, they've got to take into account safety there?
Well, I'm not sure where you're reading that in the statute.
Well, so
it's the court.
Well, but the idea would be that's going to be the court's decision, but DOJ, anticipating that they're filing a motion in good faith with the court, should also be prepared to say that they think it meets those criteria as well.
Well, again, as a matter of eligibility, we think that the clearly defined reasons that the Commission puts forth ought to be what brings a case to the court. The big problem with this statute, frankly, if you look at the program statement carefully, after the reasons are defined, there's a list of 7 factors, and those 7 factors include the seriousness of the offense. And that we strongly believe is not appropriate to keep a case from the court, that those are factors that the court weighs, and that's certainly the way we read the statute.
I think there's a lot of confusion based upon the fact that I don't actually think this statute is workable. And I think it's a confusion over the roles of what you want the various institutions to play. I think Judge Pryor's point is excellent about who better should determine the health of the person and so forth than the Bureau of Prisons. Absolutely, I would give enormous deference to that. Who better to determine the nature and circumstances of the offense? The judge. Prisons knows almost nothing about it. Be that as it may, I can't rewrite statutes, much to the relief of the general public. However, I think your suggestion is an interesting one, which is that perhaps an ameliorating factor can be if you involve the defense early on in this process, at least they're in a position to point out things to the director that may be useful in determining in an outcome, whether or not to make the motion. So my question to you is, under the law, is it your understanding that the federal public defender can represent these people at this stage of the proceedings? Because traditionally, you don't have a public defender representing defendants in a writ, in other types of proceedings. So I'd like your answer on that.
Sure. Well, since 2008, this commission has given us plenty of work under 3582 with all of the retroactive guidelines, and it has differed district to district and maybe circuit to circuit on defender involvement. But most jurisdictions do involve the defender on sentencing reductions, and that's what this statute is. It is not a parole proceeding. The Sentencing Reform Act is clear. We do not have parole. It is a sentencing reduction, which is an adversarial proceeding in our point of view. I would also say that ethically as an attorney, I have an on-duty, ongoing obligation to my clients to provide them with a duty of loyalty. I have many of the records the BOP seeks for these individuals. I can get other records very readily. So I do think that there is authority for us under 3582 and the CJA to take on the limited role that I envision, Your Honor. I do think that indigent people in the Bureau of Prisons are not abandoned by the Sixth Amendment, nor their obligated attorneys to continue to fight for them in every appropriate avenue.
I have a question on foreseeability. So, post-Booker, every defense attorney worth her gold is going to raise with me the person's physical problems if they've got an illness. I can't think of a situation where cancer hasn't been raised or a severe mental illness or some such. I mean, it comes up routinely in sentencing hearings. And sometimes I'll vary based on the fact the person has cancer. I've already sort of reduced the sentence. Or, frankly, often the Assistant United States Attorney agrees to reduce it because of that. So at what point, I understand you're saying that it's a flat cutoff. You know, that compassionate release can't be granted if the court considered it. But at some point when I consider cancer, I just know the person has cancer. I'm not thinking they're at final stages of death. So I see it as being a factor, but maybe not a brick wall. How would you word it?
I think the foreseeability issue is a bit of a red herring. I mean, aging is always foreseeable. So to suggest that foreseeability is a disqualifier seems to me to ignore some of the factors. Now, it is used as a basis for refusing to file. I have had a case myself where BOP said, well, exactly as you say, the person had the early stages of cancer. Therefore, we are not going to file. We think that, just as you suggest, Judge, you may have known that it was a mild or early stage. But if it gets to stage 4 or a very serious stage, you may well feel that allowing the person to go home to die with their family is a compassionate and appropriate thing. So the foreseeability issue, it seems to me, is for the court, certainly where illness is concerned.
Your impression is that right now it's if the judge mentions it or varies based on it, the BOP won't file the motion at all?
I have had a case in which that occurred, and I have heard stories of other cases. I don't know whether it's a flat policy that if the judge mentioned it, that a case can never go back. I don't know that.
Your Honor, I'm not sure that I understand the BOP to look that closely at what happened at the sentencing hearing. The fact that the condition existed at the time of sentencing is what I think is considered. And I would note that there are a lot of individuals for whom the court can exercise no discretion because they suffer from mandatory minimums. Before Booker, it was also mandatory guidelines, and your physical health was a discouraged factor for departure from those guidelines. So there are many people who may have had a condition at the time of their sentencing to which the court felt it could do nothing about. So there are a number of people within the BOP that would fall into that category as well.
Anybody else have any questions? Thank you very much.
Thank you.